Good morning, everyone. Before we look at how standing work in the UK and Malaysia, we first need to clearly understand what standing or local standing means and why it is important in judicial review. Standing is the legal rule that decides who is allowed to bring a case to court. In simple terms, it answers the question, does this person have the right to challenge a public decision? The main purpose of standing is to make sure that judicial review is used properly. Courts review whether the government has acted legally. But not everyone should be able to bring a case just because they don't like a decision. Standing helps the court filter out weak, irresponsible, or purely political claims and allows people who have a real stake or genuine public concern to bring their challenge. In the UK, this rule is found in the legal test of sufficient interest, which comes from Section 31 of the Senior Court Act 1981. This test is flexible and depends on the situation. A person does not always need to show personal harm, but they must show a real and genuine connection to the issue they want to challenge. With this basic understanding, we can now look at how idea of standing has developed over time and how today's rule help court balance access to justice with preventing misuse of the judicial review process. Thank you.
Thank you, Samir. Today, I'll explain the law of standing in UK judicial review, its purpose, nature, and historical development, and then briefly compare it with another common law jurisdiction. Standing or locus standi determines who is entitled to bring a matter before the court. Historically, courts were strict. As stated by Lord Wilberforce in the famous 1982 Inland Revenue Commissioners and National Federation of Self-Employed case, an ordinary taxpayer generally has no sufficient interest to challenge the tax affairs of another taxpayer. This principle reflects a concern that courts shouldn't be flooded with tribal or vexatious claims from people without a real stake. However, Lord Diplock in the same case acknowledged exceptions. He emphasized that it would be a serious flaw if pressure groups or public-spirited individuals were barred from holding public bodies to account just because of strict technical rules. Thus, the courts developed the sufficient interest test to balance access to justice and prevent abuse of process. Under this test, standing is not just about personal, financial, or legal interest. Individuals, groups, and NGOs can have standing if they can show a genuine real stake or concern in the matter, specifically in cases raising the public law issues or matters affecting the public interest. When assessing standing, courts consider factors including the applicant's connection to the issue, the seriousness of the complaint, and whether the claimant is an appropriate person to bring the case. Cases involving environmental groups or human rights activists demonstrate this flexible and pragmatic approach. Comparatively, in other common law countries like Australia, a similar special interest or sufficient interest test applies, but the courts have at times taken a more liberal approach to allow public interest litigation. In sum, the UK approach seeks to enable judicial scrutiny of government decisions while preventing an overload of litigation from those without a real interest, balancing access and efficiency in public law. Thank you.
In this part, I will explain the historical development of standing in the UK up to the 1982 Fleet Street Council's case. I will show how the law shifted from a strict private rights model towards more flexible, sufficient interest, approach that shapes judicial review today. Originally, standing was extremely narrow. Courts focused almost entirely on whether your own rights were directly affected. Anyone without a personal or proprietary interest was simply treated as a busybody. At that stage, judicial review functioned almost like a private remedy. Its whole structure reflected what has been described as a narrow private rights model. Only those personally and directly affected could bring proceedings. Public grounds were hard to challenge. Because of this narrow test, many public grounds could not be challenged unless AG acted on behalf of the public. But since the AG is part of the government, this was extremely unlikely. As a result, important issues of public legality often received no judicial scrutiny. Despite the strict model, Courts occasionally recognize standing in exceptional circumstances. One important example is R and Hampton RDC, where the court allowed a neighbor to challenge a biased planning decision, even though he had no proprietary interest. This shows that where legality was balanced, judges were sometimes willing to relax their usual requirements. Another early example of the court's intervening despite procedural limits can be seen in Worthington and Jeffreys, a case frequently noted for illustrating the clear invalidity could justify judicial action, even under a restrictive approach. But these instances were rare and did not form any consistent principle. By the late 1970s, a clear tension had developed. Courts wanted to avoid opening the floodgates to activist groups, yet the strict private rights model left many unlawful government actions entirely immune from challenge. At the same time, a few pre-1982 cases hinted at a slow shift. For example, in Chamber and Home Secretary, the courts acknowledged that individuals could have sufficient interest in procedural or exception-based claims even without traditional legal rights. Similarly, in R and Liverpool cooperation, recognized group standing where a collective interest was directly affected, signaling a departure from the purely individual model. These developments prepared a ground for the doctrine shift in 1982. The National Federal of Self-Employed challenged a tax arrangement largely benefiting Fleet Street casual workers. The key question was, does the taxpayer group have sufficient interest to challenge how the revenue enforces the law on others? The House of Law said no, but more importantly, the judges reshaped the understanding of standing. There are two clauses, and the first clause is standing must be assessed in context. Lords Wilberforce, Fraser, and Roscoe held that standing should not be a rigid technical barrier. Instead, courts should look at the context and gravity of the alleged illegality and the overall merits before deciding whether the claimants had a sufficient interest. The second quote is Diplock's single simple test. Diplock took a more progressive view. He argued that standing should focus on whether the applicant raises a serious question of public legality. If yes, they should normally be allowed to proceed even without personal loss. He rejected the old person aggressive model entirely. To conclude, standing evolved from a narrow, highly restrictive private rights model into a more flexible safeguard of public. Fleet Street Casuals marks the moment when courts recognize that ensuring lawful governments sometimes requires permitting applicants without personal harm to bring judicial review.
Thank you, Nancy, and good evening. My name is Daniel. Today, I'll be discussing the modern UK approach to standing in judicial review. This shift particularly following the 1982 case of Inland Revenue Commissioners and National Federation of Self-Employed and Small Businesses, where in this presentation, I will refer them as RSC and NFSE, which has redefined who can bring a case to court and why this change is not just a technical change, but a more philosophical move towards greater justice, transparency, and accountability in the government. Historically, standing in the UK was a narrow concept. It was based on the idea that only those with a direct personal stake in the matter could challenge public decisions in court. Taxpayers, for instance, were not allowed to challenge another taxpayer's tax affairs, and organizations without a direct financial interest were excluded from bringing judicial review claims. This was a strict approach, grounded in the belief that only those directly affected should have access to judicial remedies. However, in RSC and NFSC, the House of Lords changed this. They acknowledged that the National Federation of Self-Employed and Small Businesses, which were a group of individuals who were not directly impacted by the tax decisions in question, could still challenge the actions of the Inland Revenue. Lord Diplock famously warned that it would be a grave lacuna in our system of public law if groups like the Federation were prevented from bringing their concerns before the courts, especially if their aim was to challenge unlawful conduct in the public sector. His views was not just technical rules of locus standi, or standing should not prevent legitimate public concerns from reaching the court. This marked the shift towards a more flexible and inclusive approach to standing, one that will allow individuals, groups, and organizations to seek judicial review, even when they did not have personal stake. Today, standing in the UK is determined by the sufficient interest test, outlined in Section 31C of the Seniors Act 1980 and was previously discussed by my peer, Noshin. According to the statute, an individual or a group must demonstrate they have genuine concern about the decision or action they are challenging, rather than just a personal interest. The sufficient interest test ensures that judicial review isn't a free-for-all. Courts still examine the nature of applicant's interest. Is the applicant's concern genuine and connected to the matter being challenged, or is it just an attempt to litigate for publicity? Another being the public interest involved. So if the issue has wider societal implications, does the applicant represent a group whose legal rights are affected? And the justice of the case, where are there other mechanisms or alternative remedies available, or is judicial review necessary to correct an unlawful act? Cases such as R and Secretary of State for the Environment, ex parte Greenpeace Limited, reflects this liberalization. In this case, Greenpeace, though not directly harmed, was granted standing to challenge the government's decision to license a nuclear reprocessing plant. The case demonstrates how the courts move towards a model where public interest matters could be heard, even if not direct, financial harm was involved. The modern approach to standing is built on several key principles. Number one is context sensitivity. Courts recognize that not all cases should be treated the same. The question of standing depends on factors like the nature of the decision, the connection of the applicants to the decision, and the public interest at stake. Number two is the public interest standing. The courts inclusive grant standing to those acting in public interest, such as organizations concerned about environmental protections or human rights, if their claims are based on legal principles and not mere ideological or political agendas. Number three is the discretionary nature. Standing is not automatic. The courts use their discretion to filter out claims that are frivolous or would unduly burden the legal system. But as Lord Diplock stated, the court should avoid using technicalities to deny access when lawful conduct is being challenged. This approach reflects a deeper philosophical shift. By expanding standing, the courts have positioned themselves not just as arbiters of disputes, but as the guardians of the rule of law. This has wider implications for the balance of power between the individual, the state, and society. As we saw in RAC and NFSE, standing has evolved into a tool not merely to prevent nuisances, but to ensure public bodies exercise their powers lawfully and are held accountable when they don't. Now, after RAC and NFSE, several key cases show how standing has been increasing granted. First one being R and World Development Movement Limited and Secretary of State for Foreign Affairs. This case allows an NGO to challenge the government's decision regarding international aid, demonstrating the public interest litigation was now permissible. Number two is R Good Law Project and Prime Minister and Anor. In this case, the court emphasized that standing would not just be automatically granted to organizations just because they are in the public interest, but judgment confirmed that public interest standing remains as an important avenue for challenging public law decisions. These cases illustrate how the courts have moved towards a more inclusive and flexible model, where groups and individuals concerned with upholding the rule of law can step in to challenge government actions, even when they are not directly harmed. The shift in standing law aligns with a broader philosophical shift in how we view the role of the courts in society. Historically, the judiciary role was largely seen technical, focused on disputes between private parties, but with the modern approach to standing, the judiciary has assumed a much more active role in maintaining public law and order. The modern stance reflects a belief that the rule of law is not just about protecting individual rights, but about ensuring the legitimacy of public authority. What we see today is a recognition that justice cannot be limited to those with a direct personal stake. The judiciary must protect the integrity of public law, even when no individual is directly harmed. By allowing public interest litigants to challenge unlawful conduct, the courts embrace a broader vision of justice that encompasses the well-being of society, in line with democratic values and the desire for an accountable and a transparent government. In conclusion, the modern approach to standing in judicial review reflects a moral commitment to public accountability and the rule of law, which, while it still maintains a safeguard against frivolous claims, it has opened the doors for public-spirited individuals, organizations, and NGOs to challenge unlawful government actions. This reflects a shift towards a more inclusive legal system that recognizes the importance of access to justice, not just those with direct or financial harm, but for anyone concerned with maintaining a just and lawful society. Thank you. Now I will pass it on to Iman.
Thank you, Daniel. My name is Iman, and in this part, I'll be talking about how locus standi works in Malaysia and how it compares to the UK. First, the legal foundation in Malaysia. Judicial review is governed by Order 53 of the Rules of Court 2012. Under Order 53, Rule 2, Subsection 2, a person may apply for judicial review only if they are adversely affected by a decision, action, or omission of a public authority. This requirement serves as a threshold test. Not everyone can just bring administrative law claims. There must be a real connection between the person and the public authority's decision. How do Malaysian courts interpret adversely affected? The test is that the applicant must show a real and genuine interest in the subject matter. Importantly, the Federal Court in Malaysian Trade Union Congress versus Menteri Tenaga Air and Communicasi held that an applicant does not need to prove that a private right was violated or that they personally suffered special damage. In other words, standing in Malaysia is not limited to people whose personal rights have been clearly harmed. Public interest or more collective interest can suffice. A very important modern case is Perbatanan Pengurusan, Trellises, and Oz versus Datuk Bandar Kuala Lumpur, decided by the Court of Appeal and later affirmed by the Federal Court. In that case, the court held that under Order 53, Rule 2, Subsection 2, people did not need a specific statutory right to challenge a decision. What matters is whether they are adversely affected, as defined by real and genuine interest. The court also noted that the locus standi rule must be read liberally, especially in public law cases, so that individuals with a genuine interest in public affairs are not unjustly shut out. More recently, the federal court has explicitly endorsed a broad and liberal test for standing in Nick Ellen Zonera and Anor versus Kirajan Negeri Kelantan. The court held that residents, proprietors near public land, even if they don't have a special legal right, can show genuine interest and be considered adversely affected. This reflects a strong shift. The courts now recognize that public interest litigation is important and genuine community interests deserve access to judicial review. But there are limits. The adversely affected test is still a gateway. Not everyone can jump in as a concerned citizen. Courts will assess whether the interest is real, not speculative. For example, in Khairuddin versus Attorney General, the High Court rejected a challenge because the applicant failed to show how he was adversely affected. Being a taxpayer citizen alone was not enough. So while standing is more open today, procedural and factual hurdles remain. Now, comparing with the UK, in the UK, standing in judicial review is tested by whether an applicant has sufficient interest, which is flexible, context sensitive, and allows for public interest litigants. Malaysia's test, adversely affected with real and genuine interest, is conceptually similar in that it is not limited to strictly personal rights, but Malaysia's formulation is explicitly tied to being affected, which acts as a clarifying filter. The recent liberalization in Malaysian law brings it closer to the UK model, especially in public interest contexts. However, Malaysia still retains a strong threshold test that ensures only genuinely connected applicants can bring judicial review. Now, let me evaluate the strengths and weaknesses. For strengths, the modern test empowers NGOs, residents, civil society to challenge public authorities. It strengthens accountability and respects the rule of law. And when talking about weaknesses, the real and genuine interest requirement may still exclude some people who care about public welfare but lack strong personal stake. Costs, procedural barriers, and provoking adversely affected should still deter public interest litigants. In conclusion, Malaysia's approach to standing has evolved significantly. from a restrictive right based test to a moral liberal interest based model. Through the adversely affected test, courts now allow broader access, particularly for public interest claims, while still maintaining a threshold to prevent abuse. Compared to the UK, Malaysia's law is converging but retains its own distinctive features. Overall, this development is positive for public law and access to justice. Thank you.
To conclude, the development of standing in judicial review, both in the UK and Malaysia, shows a clear movement away from narrow technical barriers and towards a more principled commitment to the rule of law, accountability, and access to justice. In the UK, the journey began with a strict private rights model where only those personally affected could challenge public decisions. As Lord Wilberforce noted in IRC versus NFSC, a mere taxpayer generally has no sufficient interest in another person's affairs. But this narrow approach increasingly failed to protect public legality. Lord Diplock's warning in the same case that it could be a grave lacuna in our system of public law if public spirited applicants were excluded marked a fundamental shift. The modern sufficient interest test under the Senior Courts Act 1981 now allows individuals, groups, and NGOs to bring claims where they raise serious questions of legality, even without personal harm. Cases like ex parte Greenpeace and World Development Movement demonstrate how this flexible approach strengthens judicial oversight. In Malaysia, the evolution mirrors the UK's but develops through its own statutory language. Order 53 requires applicants to be adversely affected, but courts have interpreted this increasingly liberally. The federal court in MTUC, Taman Rimba, Kiara, and most recently Nick Ellen, confirmed that applicants do not need proprietary rights or special damage, only a real and genuine interest. This brings Malaysia close to the UK's approach while still requiring a clearer connection to the decisions under challenge. Both jurisdictions now recognize that judicial review is not just a private remedy but a mechanism for defending public law itself. Standing functions such as a filter not to block public participation but to ensure that the courts hear claims brought by appropriate and genuinely concerned applicants. The goal is balance, preventing frivolous or politically motivated litigation while ensuring that serious allegations of unlawful government action are not left unchallenged. Ultimately, the modern law of standing reflects a shared constitutional principle. The rule of law cannot depend on the government choosing to police itself. A flexible, inclusive approach to standing enables courts to act as guardians of legality, ensures that unlawful administration's conduct is brought to light, and empowers civil society to hold public authorities accountable. While the UK emphasizes sufficient interest and Malaysia focuses on being adversely affected, both systems now converge on a common vision, one that values public interest, transparency, and the fundamental importance of accessible judicial review in a constitutional democracy. Thank you.